what the day is.
Yeah, what a day. What a day. Let me get all the, come on, just throw them at me.
First, happy MLK Day. The best day ever to celebrate MLK.
And for those who don't know what he's saying, Martin Luther King.
Wow. If you don't know what MLK stands for, something wrong.
Well, someone out there don't know what MLK means.
Maybe Donald Trump, but other than that.
Anyway, how was your weekend, man?
Yes, sir.
So, welcome to another Warriors United for Christ. Warriors United FC. The FC stands for Christ because we love God and we will never say we don't. We're not ashamed.
Exactly.
So right. God is good. So welcome everybody to the show. Hey, gentlemen, power-packed weekend.
Yes, it was.
Some of us had a good weekend. Some of us had not so good a weekend. Tell me. I'll start with Mark.
Since you put it out there like that,
the golden boy.
Well, let me go from this aspect. First, start Man United. They win one, then they lose one.
They get crushed.
They got crushed horribly.
At home.
I mean, that was the worst display of British football I've ever seen.
They need some work, but they'll be fine.
Anyway, and the good news.
And then the NFL, the team that everybody will call scabs, losers,
Redskins,
Redskins. We up towards the finals. Yeah. So we got one more hurdle to overcome. And if we do that, then we'll see.
You know, the great thing about that is you have a coach, first-year coach, who's already been to Super Bowl, but he's also the coach who's most infamous for being up 28-0 in the Super Bowl and still losing, which is ridiculous. But Dallas seems like they lost that coach, and this coach comes and takes his team to the Super Bowl. So
every time we have a discussion, you're gonna say Dallas, man.
Exactly.
I mean,
who's that?
I mean, I know we just joined you on the couch, but you've been on the couch for 6 weeks.
I've been on
man.
11.
Why every time we're gonna say Dallas? You don't even have a coach,
right?
Right. That's how good we are. Even when we lose, we're in the news. This doesn't make a difference. That's how good we are. That's what it is.
Don't make me choke, man.
Anyway,
yes. That heartbreaking loss again. 2 years in a row, we get in the end zone, and 2 years in a row, they drop the ball. So, hey, look, I can't say nothing about it. Just another heartbreaking loss again. But my soccer team won, Birmingham City, on top of the league, 4 games up. And apart from that, we had a great, a lock-in. We had a lock-in at the church. For the youth. Yeah, Friday night, 9:30 till 6 in the morning. Woo! There was about 80 people there. 80 combined. Youth, 80. They had a time. Let me tell you, they had a time. So I had a section for where the 5 to 11 kids, they was in the choir room, where it had a lot of room where they were watching TV. They were playing games in there, and they were allowed to sleep, the 5 to 11. And then from 12 up and up, yes, it was great.
Oh,
it was great. Yeah, so there's like 60 youth and adults in there. So they went from games, praying, worshiping, running around church.
Right.
Yes.
And the national youth president, LJC, the national internet. What is LJ?
Coffee House.
Coffee House.
He was there in attendance.
Exactly.
So that was a beautiful.
And Lady Wynn, she left around about 11 o'clock, 11:30. Okay. Yeah, so she was there for the beginning. But that was a great night.
Yeah.
Yes.
That sounds awesome.
Yeah, I stayed up for the whole thing. You're welcome. So apart from that, it was great.
And you got this bipolar weather that's going on around here. You just don't know what's going to happen. I mean, down south is getting weather that you never heard of before. We're used to it. But further south, man, they are Tennessee. They don't get snow, but now they're getting it.
Yeah. How was your weekend, though? Anyway.
My weekend was very good. I can't complain. It was a great weekend. We had an awesome service on yesterday. We enjoyed ourselves and it's been a good weekend. This is a good weekend. And today was a nice, relaxing day. And we're just happy to have such great weather here in New Jersey.
Yeah, kill all that smog and
Yeah.
stuff you got going up there. But before you say anything else, you need to say,
Yes, please. Look, we got people coming on, and this is great. But you know, I got to do what I got to do, and I got to say what I got to say. People, we love you. We want you to subscribe with us. Push the share button. Push the like button because we love you. I don't care. From New Jersey to Silver Spring to Baltimore, we love you. Anyway, push that button. We love you.
So I have a question. Have you guys ever looked into wills and trust?
But before he does that, I want to know why his picture looks so bright. Is it because there's maybe some kind of sunshine around him somewhere? Because he looked really bright today.
Let me
Why?
introduce this one. Let me introduce this
Of
one.
course you can.
This is why he's all bright tonight.
Yes, this is why you bright. Even though she don't like me, but she bright.
It gives me great pleasure to talk about this individual about to come on. She's a special lady who has been, I've known all of my life.
Be careful.
I've had good days. I've had some bad days.
I've had some good days. I've had some hills to climb.
She had taken care. She's done well to take care of my parents when my mom was alive and when my dad was alive. She's been good. Just like every Jamaican nanny's always been good. She's been good even to my daughter, her niece. She's going to come on today to talk about wills and trusts. And we're going to trust that she knows what she's talking about. No other person than my sister, Debra Johnson. Hey, clap your hands.
Hello,
Welcome, Debra. But he referred
hello.
you as a Jamaican
nanny?
You know what, Mark? I'm just going to go ahead and pray. That's all you can do at some point. You just pray.
Oh, wait a minute. We even just started. Okay, Mark. We're just going to pray. Okay, fellas. No. Okay, Mark.
I am happy to see you all, even my interesting brother. So glad to see you, Simon, as well, and Mark. And maybe next time, though, one of you can do the introduction. Okay, how about that?
That'll work. That'll work.
Oh, no. Next time we'll let Mark do the introduction.
So, Debra, so tonight we're going to be talking about wills and trust. And with you being a legal person, help us understand it a little better.
Well, I'm glad you asked that. Because honestly, I feel so passionate about this subject. It is baffling to me how people can work so hard for all of their money, their property, work years, and then just leave and not make any sort of plan for what happens to that. Or to the point in some states where all of it will go to the government. In some states, it will go to different state entities because you didn't take the time to sit down and say, okay, I worked so hard. I want my kids to have this. I want my cousin to have this. So what a will does, it says, this is the plan for all the property and the things that I have earned and put together during the course of my life here on earth. Here's the plan for what happens to it when I'm passed. This is the plan of what happens to my children if my spouse and I should be in a horrible accident and we pass together while they're still minors. This is my plan. If we both pass when my children are minors, this is my plan for their guardians. This is my plan for how their money will be spent. So I, as a parent of young children, the worst case scenario, if my spouse and I die simultaneously, I have a plan for my kids. I'm looking out for them even after I am gone. So what a will does, it says, all that I love, I'm going to protect for as long as I can, and or I'm going to make sure it goes to the people that I care about or the entities that I care about. It takes just a few minutes or a few hours to make sure that all that you have worked for or all that you care for is protected. That's what a will does.
And what about
you can tell that I feel seriously about these wills, right? Because many times in our community, we don't take the time to do that. I find that among certain of my clients, they immediately, as soon as they have a child, they're looking at my door. Can we get this? Can we get that? For protections. They have whole plans, the wills, the advance directive, the power of attorney. And this is not even people that are older. While I can't tell you how many workshops Pastor has called on this subject to be able to get people to do this. And because if you're a member of our church, you'll say, okay, you know, I'll do it discounted. I want to make sure it gets done. I talk it through, do the consultations. He has done this on numerous occasions. My dad did it once before, and still it's hard to get people to consider this. Some people think, oh, if I start considering my will, I'm going to die. And that's not the case. One doesn't lead to the other.
What
So
people? What people are you talking about, Deborah? What?
People whose names are Rupert. No, I'm only kidding. You're not like that, to be honest. You're always forward thinking. I think sometimes in some traditions, even among my fellow West Indians, there's some of us who are nervous about wills, as if by conjuring up, planning for your death, it will lead to you closer to your death. And that's not been my experience. It's been my experience that people who plan ahead often are the ones who seem to somehow live longer. Maybe it's because they're better planners, but I don't think one leads to another. So I'm not saying that's the case with all fellow West Indians or even African Americans. I'm just saying that there is a number that I know of that have felt that way, and it's made it harder to convince them.
So what you're saying is that we, as the darker toned folk, have a harder time getting these wills done. Is that what you're saying?
You said darker.
You said darker.
So
are you saying something to me? I mean, please.
You're still darker toned. I didn't say you.
Oh, darker tone.
I
Oh,
said darker tone. I didn't say dark tone. I said
half
dark.
and half or something like that. Come on.
I think I gave the impression of maybe skin tone, but what I meant to say is that there's some cultures and ethnicities that it seems to be a little harder to convince them the necessity of having a will or an estate plan at all.
Just say black folk, because we know it's black.
So yeah, Deborah. So where does a trust come in?
You know what? That's a very good question, Mark. Was that Mark? Who was that? Oh, it was Simon. Then it was an okay question then. And so, but actually, that was actually a very good question, Simon. Lots of times people do trust for different things. For instance, let's say both parents are planning to say, let's say the worst case scenario, we die simultaneously. Then I'm going to put a trust so that there's money set aside for my children in trust, which I'll have the trustee take care of the child from that trust. Or if that child is approaching college age, they can get their education and the money from that trust. So lots of times trusts are set aside to be able to plan for children's education and their well-being should both parents die simultaneously. Sometimes a very wealthy spouse who knows that their other spouse has never really had to work and is not good with money, they will put what's called certain types of trust in their will, like a spendthrift trust, which will have a trustee give the person the money as they need to be able to live, because they know that that spouse that they're leaving is really not good with money. And they want to make sure that that money is not blown or taken from them by other relatives who are not scrupulous. Sometimes you'll need a trust if you have properties in different states. For instance, the state that I live in, New Jersey, it is very easy to probate. If you live in states like Florida and New York, it is very complicated, or much more complicated, to probate your will. And so therefore, lots of times people who may live in New Jersey or New York and they own properties in southern states or in Florida will put those other properties, particular Floridian properties, in trusts, because that trust therefore becomes a part of their estate here in New Jersey, and it's easier to probate. So there's several reasons to have a trust that's a part of a will. People will have trusts that are not a part, and those are estate trusts. There are other trusts that are not a part of the will that people set up before they die. And that may be for a different topic if you don't want to get into it, but they can be different trusts that you may set up for somebody that's in school. Maybe a college student, a grandparent may have set up a trust for them for when they go to school or college. There can be trust for people who are, but their trust in the wills are the ones that I mentioned earlier. There's a variety of different trusts.
Anything, really, right?
Yeah, you can do a trust for anything.
Questions being asked. So let's talk, because you mentioned probate a couple times. Everybody may not know what probate. What do you mean by probate? So the question by Ann was, do wills go through probate? But why don't you tell us what probate is and then discuss that part?
Hi, Ann, number one. But yes, actually, I could talk about both at the same time. Probate is the process where a will gets finalized by the government. So you take your will to the probate court. In New Jersey, it's the surrogates court. In Maryland, it's called the orphans court. In different states, you go to the superior court, like North Carolina. But here, for instance, in New Jersey, you go to the surrogate's office, not court. Actually, in New Jersey, you don't have to go to court. You go to the surrogate's office. You talk to them, you give them the will, and for a price, they will give you what is called the letters of executrix or executor, which will allow you, therefore, to go ahead and handle the estate. So the probate process is the process where the executor gets the necessary paperwork to be able to handle the business of the estate.
And can anybody be executor?
Whomever the person names in the will, but I would suggest that the person named in the will is somebody that is very competent, somebody that can handle things, somebody that's going to be able to sell the house and give it to the heir, somebody who's going to be efficient and on top of things, and somebody that can handle people who are going through grief. Because when you're going through grief, you're often not your best. So you're going to need someone who's going to be able to navigate the different family members. And if there is a family member, then you pick the family member that would make the most sense to the family. And if it's not a family member, then you pick someone that would make sense to the family, and a family attorney, someone they could understand. And no matter what, there's going to be some family members that will never understand, but you try to pick the person that's the most competent, or in rare occasions, I would recommend two people. If your spouse has already passed, and you have two adult children and they're both equally competent and they're close in age, just do two of them. And they work well together, just do both of them. That way it doesn't leave any, because you're already going through grief and torment. Just do both of them. If it's my thought. Because today, remember, I'm not giving you legal advice. I'm just giving you some legal information. But if it's otherwise, though, I would say it's one person so they can get the job done without having to call the next person all the time.
So my next question is, and my name is Mark. So I'm just going to let you know, my name is Mark. My next question is that, okay, so if, let me just say parents do leave a will, okay, and there are 4 or 5 children, and one, okay, I'm talking about myself. I'm talking about myself.
Yeah, I gathered that already, so go ahead.
Yeah, so, but my name is nowhere on my parents' will, apparently, but everyone else's was. I was supposed to get a letter, but I didn't get a letter. So my sister, who's advocating for me across the seas, she's giving me information and all information. So what I guess he's asking is I'm not sure where I'm going to push this from, because she's trying to do the legal factor on how do I find out if my name was really on the will or not on the will, because everyone in my family got a letter, but I didn't.
In other words, I guess, was the will altered?
Yes.
Well, I think it's hard because this is an English will, correct?
Exactly.
So I'm so sorry, Mark/Simon.
You're welcome.
But I really don't know the laws in England. I'm not aware of how that would work. I would imagine that if you didn't receive the same thing everybody else received, it could simply be something as simple as they don't have your correct address. It doesn't have to be anything complicated. It could simply be that things get lost, legal documents all the time, because they send things abroad and they think they have to put the letter together like they do in that country, and they don't. Or sometimes they simply have the wrong address, or was sent to the wrong address and it wasn't forwarded. I believe that you could probably Google and research how wills are handled in England, and then find out from whichever office handles it if you are entitled to get a copy of your will if you prove that that was your parents.
Yeah, well, we're doing that right now. So
okay, well, I think that was smart.
It was nothing to do with the address. Trust me. It was nothing to do with no wrong address. But we're doing that right now. And my sister, she's talking to someone right now to see how legal, whatever we can do, how we can go about it. If I can get one, or they can send me one, a copy, or anything like that. So, but anyway, that's not about my story anyway. So,
well, but at the end of the day, she can always send you a copy of everything she gets.
Yeah. So,
yeah.
Oh, she's done that. Yeah, we've been reading. We've been good. But I appreciate
to me,
that.
It looks like your family's on top of things and is already pretty much taking the course that I would have if I had been in your stead. So it looks like they're pretty much doing.
Yeah, I'll see you offline.
Getting to the bottom.
You're welcome.
But,
Well,
but speak, but Debbie, sorry, Mark, but speak to it because it's not because it's a probably a normal question or it comes up often where one of the children or somebody's left off of the will, and they're wondering what could they do? What could they do in the United States? What could they do? The address is wrong. That we understand, but what could they do? Do they have to get a lawyer to go and talk to, or what? Do you talk to your family first? Like, what would be the steps that you would advise somebody?
It's so different because even every state is so unique. Here in New Jersey, when I craft a will, I have to be exact. In North Carolina, it does not have to be as exact. So it depends. For instance, I have said in wills, and it hurts my heart, but I've said in wills to my parents have requested this. I leave everything to my 3 children. For my 4th children, I leave $1. That way there's no mistake that they weren't supposed to get anything. Or I've had a will where to my 4th child, I leave nothing at all, and I do this intentionally. So here in New Jersey, there is no confusion. They put in the will, I have to craft in the will. If you're leaving somebody out, I have to craft in the will that you intentionally left somebody out so that there's no confusion. Some other states, it's like whoever's written there who is getting it. We're not going to try to figure this out. If it's not written there, the person was in their right mind and sound. They know what children they have. They know what cousins they have. They know what siblings they have. They know who their parents were. If they didn't put it in there, it didn't count. New Jersey, we take that extra step where we actually will say, you're not getting anything. So it's often the case in the United States of America, though, that you can contest the will, but if it's properly drafted by an attorney, it's hard to think that you're going to win. If it's handwritten, then there's a possibility. Most states, I do. I know the states that we all live in, they take handwritten wills. But in New Jersey, we don't take like those deathbed oral wills, we don't take. I believe Maryland, in certain circumstances, may. But at the end of the day, I would always recommend to everyone to have a drafted will by an attorney. They rarely fail. And in the time of money and effort and pain that it does to contest the will, I've had only one of my wills contested and it lost. And the time of money, my will won. The person going up against it lost because you won't win against those type of things. So I don't know if I answered your question, but I wanted to say that most wills are drafted here appropriately in this country that I know of, and it's rare to ever win.
Well, good.
One question for you. I've heard the term pour over will. What exactly is that?
A pour over will?
Yes.
I'm sorry, I'm not 100% sure. I have heard it too. We don't really have many pour over wills here in New Jersey. If you take a second, though, I will try to get that information for you. So ask another question while I will find that out for you.
Yeah, wait a minute. Scroll down a second because I know there's some people who haven't been on our show before. At the beginning, I know they're just saying hi, but like Talia, praise him, saints. Yes, okay, that's Talia. Thank you, Talia. I will see you Sunday. Make sure you're there. And of course, Laverne Barnes. What? Laverne?
Hey, Laverne, I like what you just said there,
yes.
man. I like that.
And we keep trying to tell Rupert, you can't keep saying the Cowboys because we might lose people.
That's right.
And I just logged on. I heard the word Dallas. And
I was on the couch from week 11. Laverne was on the couch from week 3. He's a Giant fan. So how you doing?
Hey, look, we appreciate Laverne coming on the show, man.
That's right.
Appreciate you, sir.
So let's
we
do have some more questions too. We do have another question. Actually, Laverne asked the question here.
Oh,
what do you say to people who feel that you have to be wealthy with an estate to need a will?
Well, I think that everyone should have a will. I think that the necessity of a will is for everyone. If you have young children, remember we talked a little bit earlier, protections you put in place if both parents die simultaneously, a guardian and a trust. And you would want to take care of your kids whether you're wealthy or not. Even if your only assets are very limited, they're still yours. And you want to know that you have a right to see where they go. If you are a single person, if you are, let's take a single woman, and you don't have any kids, you don't have a spouse, and your parents are passed, and you say to yourself, well, what do you need a will? Because you worked really hard for your assets, and you need to say where they go, right? And you want to also do the will to the best that you can to be able to avoid having your relatives have to go to court to be named an administrator of all that you have acquired. And even if it's just a little thing, you have a car, you have a condo, well, that's still something that you've acquired. And you don't want to have your relatives fighting over that. You don't want to create that kind of rift after you die. What the will does is ease a lot of pain. And if you have things that you want to put in a living trust, that the trust that will be able to assist the living expenses of those that die. And what a pour over will is that anything that's not in the trust will go into the living trust and become an asset. So that's what a pour over will does. Okay. So you don't have to be wealthy to have a will. You just want to have a determination to plan for the things that you do have. And you say to yourself right now, well, the only thing that I own is a car. Well, you'll be surprised how many of your relatives will fight over a car. And I don't understand why we would want to do that to them. Just decide that my car is going to Cousin Pookie, whoever it's going to, and your Uncle Winston, I don't care. But make a decision as to what happens, because sometimes it will alleviate pain that you don't want to cause when you go home.
Yeah, I think to add to that too, Deb, right? I would just kind of look at somebody saying, look, do you want the government making a decision where your stuff goes, or do you want to make a decision where your stuff goes? Because it's going to be one or the other. And the government sometimes will just say, we'll just keep it and seize it. And nobody gets it. So just put in a will, that way you can decide who's going to get it, right? And we have some other questions that you can kind of talk to, because I think there's other thoughts on that. But I think this is the one that I think everybody is going to be concerned about.
So what is the cost of a trust and a will?
Well, it varies from state to state what it cost was. And sometimes your trust is inside your will, and it really won't make that much of a difference to the cost, depending on your attorney. Trust you can do with your financial advisor, and they will talk you through. So I can't give you a definitive answer of what they would cost. They can, in New Jersey, a simple will can be upwards of now $300. Normally, I would say it's around $2-ish. In Maryland, I really don't know. I'm going to say it's similar. An estate, though, can be, in a whole entire estate plan, though, can be $1,500, $2,000, $3,000. But that's much more intricate. And that's normally if you have a business, if you have properties in other states and other countries. Well, in other states, at least. I'm not sure about other countries. And so you would need more of an estate plan. And if you're also a little older, maybe, and you want to include a power of attorney and the living will, those are much more expensive.
Yes, in Maryland, it's $200.
Oh, yeah. So it's about what I estimated.
Wow.
Yes. Yeah. So you were right on the nose there, because I just looked it up and it was like $300 or $200 for a simple will, but up to $2,500 if you have a living trust and all that stuff. So you hit it right. So everybody, wills aren't cheap. So the more intricate they become, the more expensive they become.
But you know what? You guys don't play on this show. You fact check right away.
We try to come correct. We try to come correct.
You know what? I'm keeping my phone close. I need all sorts of protections. Oh my goodness.
Well, you know what?
Before we go any further, look, we appreciate everyone who's come on the show right now. Continue to press like, continue to press share, and continue to press subscribe so we can multiply in 2025. Thank you very much, people. You're welcome.
Amen. That's it. We got a couple more questions here. We want to get.
Yeah, we got some up there.
So Ann says, does a handwritten will have to be notarized? Well, I have a question. Why would you want to do a handwritten will? Because isn't it best to go to get someone to do it professionally versus you handwriting it?
It's always best to get someone to do professionally. And lawyers will say, well, you're going to say that because you're a lawyer. You want the money to go to lawyers. We, out of all the things that I make money on, the least is wills, because it seems like $200, $300 is a lot of money. But if I go to trial, that's my hourly wage. And it could take up to 2 or 3 hours if you're sitting with a client properly to do a will. So it's not a lot. It's a lot, but compared to other things you do legally, it's reasonable. And so I would always argue, sit down with a professional. Don't do it on LegalZoom because it's very cut and paste and it won't have whatever intricate or it's not nuanced to your own personal needs. And so a holographic will in both of our states, Maryland and in New Jersey and in many states, is a valid will. If it's signed by the person and the person, there's nothing to indicate the person wasn't in their right mind. Does it have to be notarized? I believe the wills in New Jersey need to be either notarized or it can be certified by an attorney. That is my understanding. Many times a holograph, but I have heard here that you can write a will on a napkin, and if it's clear, you can be concerned and it's signed off on, and there's witnesses that will come in and say, we witnessed it. There have been arguments towards that, but I would say that it is my opinion that a will is most legally sound if it is properly certified by an attorney or notarized. Now, if it's notarized, it's fine. That is also fine. But if you're certified by an attorney, you don't need those witnesses to come in when you're trying to probate because it's proven. It's a self-proven will once it's notarized certified by an attorney. So if it's certified by an attorney, it's a self-proven will and you don't have to have anybody come in. And I'm not 100% sure if it's self-proven. If it's notarized, I can check that for you because I don't want you all three of you fact checking me and I'm wrong. So I'm just going to double check. But I know for an attorney because I self-prove our wills. And when I do that, I know that you don't need your two witnesses to go in with you, which is good because what if your witnesses also predecease you? Then it would be trouble having that will properly, properly vouched for.
Because I was about to say, if you do a handwritten will, it's almost like you're doing a unjust service. It's kind of like someone who doesn't have to do taxes. You're going to miss out on certain advantages from someone who knows how to do tax and make sure you get everything that's entitled to you. So if you do a handwritten will, isn't a possibility maybe missing out on something or missing something completely? I'm just guessing.
You're 100% right. You're 100% right. I couldn't say that better. So.
That was Simon.
Yeah,
No, that was not Simon. It was.
I just texted that word.
Oh, wrong one. That's next question. No, wrong one. Next question.
Right.
Who is the keeper of the will once notarized, and how many times can a will be modified?
That's a good question.
All right. So the keeper of the will. Who asked that question?
Anita.
Now I know it because that was such a great question. Hi, Anita.
Oh,
so
wow.
Good to see you.
Oh my God. What's this bro? This love. Come on. Jesus.
Here we go again.
So the keeper of the will, oftentimes you can keep your own will, right? What I do is I do two originals. So I keep a copy and my client keeps a copy. And that way, though, when my client predeceases me, if for some reason all the paperwork gets lost, they know, here's my attorney. I tell them to tell everybody who's your attorney is so they can find me. And hopefully, God willing, I'm alive and well. If not, I have in my own paperwork who takes over my firm when I pass. And then if that person is gone, then I'll have to do something else. No, it has to be a lawyer. Okay. All right, Rupert. So you can keep your own will, or you can keep a copy of your will with an executor. Some people keep it in their safety deposit box. But the problem with that is, what if the person can't get into your safety deposit box? Because sometimes it's two keys, one for you and one for the other person, or somebody we keep it in a strong box in their home. And they just like what my mom did was she had a big box with all her legal papers. And what she said, here is the box. When I pass, you go to the box. And so you can do something like that. Yeah, well, why would you?
He didn't know about the box.
He didn't know
No,
about
he didn't know about the box. There's no need for him to know about the box.
Wow.
No, he knew about the box. He all knew about the box.
He gonna leave early.
No, he knew about the box. So you can keep your own will, and then, or you can leave it with the person who's going to be your executor that's going to handle the things, or you can have two copies. One for you, one for your attorney, one for you, one for your executor. Just make sure that when you pass, there's a person who can access that quickly. That was the first part of the question. What was the second part of her question?
How many times can it be modified?
Oh, as many times as you need to. Sometimes when I was a younger attorney, I would argue and say every 5 years. In New Jersey, what I recommend is go back to your attorney and get it looked at every 5 years or so. Or if there's a major event, you get married, you have grandchildren, somebody you left things to, you had left your house to a cousin that you knew would need it, and that cousin passed. Major events, go back. Now, in some states, like Maryland, they recommend codicils. They don't recommend you doing your wills over. No state recommends you writing on your will because it becomes not really a valid document. It's just open up to too much litigation. So in New Jersey, you can also do codicils. Codicils are amendments to the will. Many people recommend codicils because they're simply cheaper. It's a quicker document. You're just putting in a paragraph that says, I previously left everything for Jerome, but now I've decided that it's going to be both Jerome and Carol. And so you can put in an amendment and you put it in. All of our states accept it. I don't like that. Just rewrite the whole will again and have it signed by every paper, because I think it's open to being contestable. Why did amendment? My father was always going to leave everything to me. I don't even know who this Carol is. I haven't met Carol. That was coerced and blah, blah, blah. But the attorney wrote it. The attorney was there and saw that the person was in their right mind. Well, then why didn't they just change the whole will? Because it's cheaper just to do an amendment. Well, the amendment wasn't clear. Is it leaving everything to Carol? Was it just leaving the parts? Was it just leaving the estate to Carol, but everything in the bank accounts belonged to me? Because most of the bank accounts have my name on it also as well. So why would Carol get a part of that? No, just do the whole will over. Have one document. Codicils can be separated from the will. A piece of paper, I have the original. I didn't have that codicil. If they wanted that codicil, they would have given that to me just like they gave me the original, they would have given me the codicil. Maybe they didn't want to give the codicil because they knew you were going to act this way. But at the end of the day, just do an entire new will. Now, codicil is maybe $75. It's much cheaper. I don't know if it's worth the angst. But you can change your will. You can modify through a codicil as many times as you want. I would imagine you should change your will for any major life event. I had a close friend of mine whose son died, and that was her only child. So therefore, the whole will had to be clearly modified because much was left for the son and his offspring, but mostly a lot was left for the son. So that was a big change.
Poor Carol. Poor Carol. He's been modified out the will. Poor Carol.
This is kind of going to. This is a trust question. Revocable, irrevocable, and blind trust. I think this. I mean, I know the answer, but if you want to get the basic answer on this, because there is deeper answers that will take a long time.
Yes.
Actually, you actually know more about trust than I do. A revocable trust is one that can be changed. An irrevocable trust is one that cannot be changed. And remind me what a blind trust is. I don't use blind trust in my will, so I can't.
I don't remember what a blind trust is because I would not recommend it. But I think what a blind trust is a trust that is only known by the signer of the trust. But I don't know what that is. I'm not so sure.
Yeah, I've never used it. I've used mostly irrevocable trusts that cannot be changed because I'm using it in a will. Mm-hmm. So the person has passed, their issues are, they can't really change their mind. So usually I use irrevocable trust, but there are revocable trusts that the person can take back. Like I set up a trust even while I'm living for my spouse because that person, I'm just not even dealing with them. Or for a child, let's say, because I'm not even dealing with them and they can't handle money right. So I'm setting it up, but then you can change your mind and take them out of the trust and change the trust. But for the most part, in wills, I use irrevocable trust.
I was right about the blind trust. It's where a beneficiary doesn't know what's going on in the trust at all. So it's a trust that's created, but the beneficiary doesn't know what's happening. So it's a blind trust. But like you said, the best one is revocable trust. Got a couple more questions here.
So Stan says, does the executor of the will, such as a surviving spouse, have a deadline of time to execute the will?
Hello, Stan, you're calling? I think his name was Edward, but
it is. But everybody calls him Stan.
Well, hi, Stan. Thank you for your question. So is there, once you set up a will, is there a period of time the executor has? In the state of New Jersey, you have 4 years to try to get through that trust and everything to get that. Right. So you do have a good period of time before the beneficiaries can start to apply to the surrogate's court to get you removed. It's taking too long. Now in Maryland, I don't know how long you have. I know that you guys don't have a surrogates court in Maryland. You have an orphan court, and that's the court that deals with your wills and trust. So I'm not sure how many years it takes. In like North Carolina, they go directly to the Superior Court, which is where like Superior Court is where most court things are held. You know, your criminal cases, your civil cases, your family law cases, that's in Superior Court. But in New Jersey, you have about 4 years to get it done. So once, and what was the question about the executor? The first part of the question?
No, there's the executor of a will. That's all he said. The executor of a will, such as a spouse, have a deadline. That was the question.
Yeah, to probate the will, to get it all done, you have about 4 years in New Jersey to get it all done. It's usually less if you're the spouse. Who's really going to be attacking you? Because when you're the spouse, mostly everything is left for you anyway. Often is the case. So if you're the person, if you're the executor and the beneficiary, really timelines don't count. Timelines are important if somebody's going to sue you because you're taking too long.
Debbie, here's a question that I'm thinking is kind of weird, but it's probably happened. What happens if you don't sign a will, normally everything passes to your spouse, right?
It can.
Let's say you're divorced and you don't have a will. Where does that everything pass to?
Well, let me think. If you pass and you have a spouse and you have biological children, a first percentage of it goes to your spouse, but your biological children should be able to get something. They will get a percentage after the first 100,000. If the person is divorced, that divorced person gets nothing.
It goes to your biological children.
It will go to your biological children, and or in the state of New Jersey, your biological children, your children under the statute. Sorry, I'm looking up to try to think, but your children under your statute also includes your adopted children. They are also included in Maryland. It includes children from the spouse's. What do you call that? Huh?
From the spouse's
no,
children.
no. From their like if a man his fluids that he uses to produce children.
Okay.
We got sperm donor.
Yes, if the person has left something, let's say it was a young man, he got in a tragic accident, but he left his sperms to be able to produce a child.
Right.
And they were able to have and he's agreed to it. And it's written and it's done and it's written and the hospital is aware of it. Those materials can be used to impregnate wife to get a child. And that child counts as a biological child in Maryland. I don't believe in New Jersey we have that intricate. I will look that up for you though at some other time and let you know. But your children will be able to get, if you died, you had a divorced spouse, they will not get in New Jersey, but your children will get, and or your parents will get. If not, then a family relative will have to go, because if you die, then a family without a will, then you have to go through the surrogate's court to get somebody to be named an administrator of your estate.
Yes, I just fact checked this. It just makes me feel better. Because I'm really not doing anything. But it says the timeline for an executor of a will in Maryland can vary depending on the estate size and complexity. The executor generally has 1 year to distribute the estate, but the process can take longer. So that's what it says.
See, I didn't really know in Maryland.
Yeah.
It's good to know. Now I know.
You're welcome.
So
no, I'm not. Thank you, Mark.
Mark, you're welcome.
You're welcome.
I should have said,
you're welcome.
So next question. You guys want to read it?
How do you deed your home to your child without it having to go through probate? Simply goes to them at a time of passing.
All right. Well, many people who are watching the show, and by the way, thank you for that question. That's an excellent question. Who is that?
NR. She just wants to be known as NR.
Well, NR, excellent question. If your spouse is, if you have a home in the state of New Jersey, for example, and you bought it as tenant's entirety in your spouse and you were married, there is no way your house will go to anybody but your husband or your spouse. As long as this was a part of the marriage, bought in marriage and was tenant's entirety, you can try to change the deed, but you can't change the deed without that spouse's permission. So unless that spouse gives you the permission to change the deed, then you won't be able to change the deed. It'll be tenants in the entirety, and you will not be able to move that spouse off of the property. It's not going to be done unless that person allows it to be done. If your spouse is passed, or you've never had a spouse and the house is only in your name, you can go to your attorney and have the deed changed to, let's say if your child's name is Winston. So you have Winston, you go and you have Winston's name added to the deed as tenant as a tenant with joint rights of joint survivorship. So joint survivorship. That means that when you die, the house will automatically go to the survivor. It's not tenants in common, it's tenants with rights of survivorship. That's in New Jersey. And many states will allow you to go and get your deed changed. You go to your attorney, just like you had a deed prepared when you purchased the home and it was placed in your name. You can get a deed changed at most any time with whatever you want it. And normally it's rights of survivorship. I know with here in New Jersey, it is tenants with rights of survivorship. And that's how it can be done. Sometimes an elderly person wants to keep an interest, and you can do that. You could deed it to your children while keeping an interest for the time that you're alive. And then once it passes fully in your children's name, that can be done in New Jersey, and I believe in many states.
But the answer really should be put in the trust. If you don't want to put in the will, it's put in the trust, right? Because the trust then will handle it. That's probably the best way to do it. But because the problem, and I think everybody should hear this, that if you separate from your spouse and you did not remove their name from the deed, guess what? You can hate them 10,000 times. The state of New Jersey, community property state. When you pass away, they're going to get your house. They're going to get your car. If it's not off the deed, that's what Debbie's saying. It has to be off the deed. So whatever happens, you want to make sure that deed is put into your name, or you could be in trouble.
Right. And sometimes people think like, oh, after the divorce, it's automatically my house. No, you still have to go through the paperwork. You still have to go through the process of getting that deed changed, right? You have your MSA, your marital separation agreement, but you still have to go ahead and get the deed changed on that house. And the marital separation agreement gives you the ability to get the the deed changed, but you still have to get it changed to avoid any kind of problem and confusion when you pass.
Same with your 401k, same with your insurance policy, same with all those things that you had your spouse's name on and you were together. If there's any reason why you are now no longer together, Christians, God forbid, but we know it happens, please make sure you clear those things up. We got a ton of more questions here. Let's see.
Okay.
10 minutes.
Where was I?
We go with Anita's question.
Anita Broder's question.
So she wants to know about the fees. So are they factored in the cost of preparing a will?
So attorney fees need to be factored in. Normally it's just a lump sum. We give you the sum. This is what the will costs, $300. And then depending on the attorney, sometimes they'll have somebody a little bit more junior in their staff. They'll meet with you quickly, go over it, have somebody junior in their staff do it. For me, I do spend a little bit more time. If the person is older, I'll go to their home. I will sit down with them. I'll have a cup of tea. I will go over it. I'll go back home. I'll send them a draft. And then I will go back to them again and talk to them about it and bring my computer in case they had some sort of change of heart when I'm there. Okay. So I take a lot of time. I don't make money off of wills, but if a person is older, it may be even more critical. I've had young people die that was unexpected. I've had two families where out of the blue, dad died, and one was in his 40s, another one in their 30s. And so they were distraught, and I actually had to walk one through probate. She's two young kids. But at the end of the day, it's usually a lump sum fee that includes a lump sum cost that includes the attorney's fees.
Okay. All right. Oh, go ahead, Pastor Wanda Hargrove. Does this also apply to Pennsylvania?
Pastor Hargrove, praise him. Good to see you. You know what? I'm not sure what you mean. What does what apply to Pennsylvania?
I think she means the will issue, right?
The will issue.
You're always saying New Jersey and Maryland. She's saying, do these kind of things apply to Pennsylvania also?
You know what? I believe that Pennsylvania is such a close neighbor to New Jersey. You would think many things apply, but Pennsylvania does a lot of things so different. Mm-hmm. New York is very different, even though we're next to each other. So I don't want to say if you ask a specific question, because I went to school in Pennsylvania, I may have some idea I went to law school in California, but I went to undergrad in Pennsylvania. So I may have a little bit of an idea. And at one point I was barred in both Pennsylvania and New Jersey, but it was too much money just to keep up the fee when I don't practice in Pennsylvania. But if there's a little bit more specific, I may be able to get that answer for you.
But wills in general, Deborah, across the country kind of still have the same guidelines. They're just kind of minutia, as we call it, might be a little bit different. But
yes, one thing I would recommend throughout every state is to have it, like Mark was saying earlier, handwritten and absolutely notarized or certified by an attorney. It is very important, I think, even though many states accept holographic wills, typed up by your attorney as opposed to a handwritten will. I believe that is your best bet. And I believe it's important to take out all your legal documents every 5 to 10 years. And I don't say 5 as much as I used to, but at least a reasonable period of time to look at all your legal documents, because you'll be surprised what you have as a beneficiary. That person may not even be alive anymore. Things you've set aside for your parents who have been long past. You just need to take a sharp look at all of your documents, but anything that is handwritten crafted by your attorney and typewritten is almost always your best bet throughout the 50 states.
Amen. If there was a comment, you can have your will registered at in Baltimore, at least at the Register of Wills in Baltimore. That's kind of if you have a copy there too. I'm guessing other states may have it, other counties. So if you are watching the show, I would just talk to your local county, municipality, find out if there's something like that where you can do that.
Yes, I did read that. You can have it registered in Baltimore.
If
you don't do that as much in New Jersey. We really don't register our wills, but you can though.
Okay.
Can you in New Jersey? I don't know. I don't know anybody that does, but I know you can in Baltimore, and I think people do.
I don't think you can in Jersey, but maybe. If you have beneficiaries, is it necessary to have a will, or do you create a will and list again?
I'm sorry, what was that question?
If you have beneficiaries listed on your accounts, is it necessary to have a will, or do you create a will and list again?
You absolutely don't need to list them again if you have a beneficiaries listed on your accounts. So you have your pension plans. You have some accounts allow you to have a POD account, which is payable on death. So you already have a person listed there for that bank account. So if you have all those things listed, you do not need to create beneficiaries again. As a matter of fact, it may increase your tax consequences. If you have life insurance, I would not put it in your life insurance to your estate. I would create it to your beneficiaries so that it doesn't become a part of your estate, making it larger and then possibly creating tax consequences. But you still have to deal with your house. And if your spouse is passed and then you need to leave your house to someone, you need to have a will. And you still need a will if you have children, and you need to create trust for them and leave a guardian. So there's still a whole bunch of reasons to have wills, but you don't need to duplicate anything that already has a beneficiary in your will.
Yeah. Is it very necessary? This is coming from Mark. Is this very necessary to have both, the trust and the will?
No, you can have a will without a trust, and you can have trust without wills. You can have trust that already exists without needing a will. I do testimony trust, which has to be a part of the will because it's set aside for things that happen after you pass. So it's not necessary to do both. You can just have a straight will that says that I, Simon, on my death, I leave everything to my wife. If my wife predeceases me, I leave everything to my children. And if your children are all adults, then that's fine.
Thank you, Mark.
Here in New Jersey, I think it could be, I believe it's similar where you are. And I believe that's similar in Pennsylvania as well. But I'm not 100% sure. I'll check it though.
Are there tax benefits or liabilities when inheriting money, homes, etc.?
It varies from state to state. Here in New Jersey, we do not have an estate tax for spouses and or children. We do not have an inheritance tax for spouses and or children. There is a federal estate tax, but that is but I think it's, I forget how many millions it is.
1.2 at one time. I don't know what it is now.
Yeah, maybe 2 million. So if your estate is over a certain number, at one time it was like up 11 million, and there was a year where there was none, and then it would start back up again. So I want to say it's maybe, I can check that for you guys. What is the federal estate tax? What is the federal estate tax in the United States?
Oh, she fact checking herself. Okay.
Because I'm gonna do it before you guys do it to me. because you guys are making me so nervous.
Really?
If the total estate is under 13.61 million for an individual or 27.22 million for a married couple. So if your estate and you're married is under 27 million, then there is 27.22 million, then you don't have federal estate taxes. So I'm sorry, Simon, you will in fact have to pay federal estate taxes. But for the rest of us, we may not have that issue.
Okay, appreciate your conversation.
Yeah, there's definitely no tax benefits. The one thing, and I know Tom's running, but the one thing about trust, everybody, is if you want to create a trust for wealth for your family, it's not a bad idea. But you really want to do it, and you have to have the buy-in of your family. That means if you have insurance policies, homes, let it go on to the trust and get a beneficiary to then handle the trust. It's a great way that wealthy people keep wealth within their household, and it grows over time. It is very difficult to do because all the family has to agree, I'm not taking money out. I'm going to take the money that's distributed to me. But it's very difficult, but it can bring wealth over a long period of time. That's if you do have financial homes and things like that, insurance policies.
Yeah, you put it the wrong way. Yeah.
I know, right? But
Yeah,
the
you put it
problem
the
that I
wrong
have
way.
with that, because I can't, because of the thing, I can't. The
Yeah.
problem that I have with that, because actually I don't have a problem with that. That makes sense, RJ. My issue is that normally those wealthy people that do it, the person who's controlling it is the person who controls the money. They're often the person that's bringing in the money. So they can do this. For the rest of us, though, everybody's working. And so if both people are working, nobody's trying to hear that you can assign such a beneficiary to do with the money that I am dealing with. That's why in New Jersey, you can have a will where if your husband and wife, it's one will for both. And I never recommend that, because when one spouse dies, the other spouse is connected, can't change it. Right. Have your own individual wills. And I only think you need trust. If you're the only one bringing in the money, then you can decide.
Yeah, no. I'm talking about something where there is a lawyer, a legal team that handles it. Yeah, I see. I'm not talking about an individual like me handling for the house. I'm talking about you bringing enough money in there. And this is something where maybe you have businesses, you have other things you want to put in there. There's a whole bunch of stories, but that's a different story for a trust for wealth, to build wealth. That's a different thing than a will, because a trust to build wealth is not upon death only. It's over the life of everybody.
Correct.
But that's the thing else. But there's a different couple things. Past Hargrove talked about.
She talked about the will issue. Yeah.
Like that.
Business bank accounts. Yes, you can leave that in your will. But I never write down bank account information in a will. Wills become probated and they become public documents. And like in Maryland, where you could put it in a registry, that's public, is my best understanding. So if that's the case, in this day and age where people can take your identity, I never put all that information in a will. I would leave my entire estate is left to my children. And in the letter, and I give everyone a sample letter to the executor. And that letter to the executor is private. It belongs only to the executor. And that lists all the bank accounts and all the information.
Tom is already got Debbie.
Well, thank you, Debra, for being with us tonight. Hey, stay with us next week. We're going to be talking about the challenges of female pastors.
Yes.
We have a great lineup. Please join in the next week, and you'll hear us say,
You're welcome.
Go Commanders!